We're back in the Judiciary Committee, and before we get back to the retail theft bills, we're going to finish or close out the vote on H27.
Dolan?
Yes.
Thank you. So you are probably going to hear from Nigel as far as what you need to get him. And over to you, Judge Sony. Thank you for being here again.
Good afternoon. For the record, Tom Zone, Chief Superior Judge. So the bill that I have looked at is the one draft 1.1. It is a matter of policy for how you decide you wish to go forward with regard to retail theft.
And I can tell you that that's the same as introduced.
Okay.
Yeah, just that's the. Did you get a chance to see H579?
I saw it briefly.
Okay.
But I thought this was the one I was going to focus on today.
Yeah, and we're going to be taking more tests.
Okay.
But yes, and a lot of it is overlap and some of the same questions that we have.
So what I wanted to touch base on was, let's assume that you want to go forward with this policy. And the question is, how is it implemented? So I had a couple questions when I was looking at the bill. In the section on 2575, offensive retail theft, it says, it has a provision under subsection 1. It says takes and carries away or causes to be taken and carried away or aids and abets that carrying away. In new section 2577, subsection D, it says a person who acts in concert with one or more persons. And the reason I highlight that is because a question would arise is, are you intending something different from aiding and abetting and acting in concert? Because they're two different concepts. The acting in concert is not imposing criminal liability on something that does not already have criminal liability, because you already have the aiding and abetting up above an existing retail theft law. But I just wanted to point out that if you go forward with this, I think it would be helpful to make determinations as to, is there a reason you're using different phrases? If there's no explanation or no definition included within the statute, the court would be obligated to apply the plain definition from the dictionary. There is, when you look at this bill, I know that it comes across as a sentencing bill, but that's not the way it would come in a trial. There's a United States Supreme Court case called Apprendi, and our Vermont Supreme Court has decided a case called Provost. And under those cases, whenever you have a conduct that would increase the potential punishment, such as here, that is something that has to be proven to a jury. So if you have a case that goes forward with, let's say, 3 separate retail thefts, the jury in one case has to decide beyond a reasonable doubt each of the elements of each of those 3 retail thefts. It's not something where you say, well, they were convicted in Chittenden of this happening on January 3rd, and they were convicted in Rutland on January 5th, and they're within 14 days, and you get another one. No, you have to have one trial where each of the events are proven beyond a reasonable doubt to those 12 men and women.
So can you say it again? I just want to follow.
No, that's fine. Yeah. So right now, if someone is charged with a single charge of retail theft, let's say in Rutland County, they would go to trial, and the jury has to decide whether on that day in that county they committed the crime and each of the elements of retail theft. Under this new bill, even though it says there's a punishment if you act in concert of this felony punishment, what it would mean is that you have to, if you're going to aggregate the value, you have to, in that Rutland case, not only prove that Rutland case, but if there was 2 other cases that came subsequent to that one case, they all have to be proven in the same trial, or else the court cannot sentence under this enhanced punishment. Because you are entitled to be found guilty beyond a reasonable doubt on each of the elements that are going to increase the punishment like that. You can't take one from Rutland, Bennington. It's not a sentence enhancement that, well, you have these other convictions, because this is conduct.
Do you have a solution to that?
So, because I was going to ask if you're using an example that has different counties, is that what matters here?
No, the same county. If you have Rutland and there was an offense date of January 1st, January 2nd, and January 3rd.
Right.
Your trial has to prove January 1st, 2nd, and 3rd.
Right.
And so that has to be in one trial. You got to prove it all. It's not a matter of, well, we proved the January 1st already, and then you find out, let's say 3 months later, that they did the January 2nd one. You can't go back and enhance sentences just by saying, well, see, the conduct fit within those 14 days. It happened. You have to prove it in one trial.
Right. No, so 3 different instances in that 14-day period is all one trial that you have to prove.
Correct.
Right. Okay. Yeah. No, I think that.
And that is irrespective of whether it's one county or multiple counties.
Right. Right. Joe had a.
If there is multiple counties, one thing I was wondering is that, when you said that, so let's say if they go Rutland on the 1st, Middlebury on the 2nd, Burlington on the 3rd, and they get caught in Burlington. So does that, if
Are
we
you
have.
peeking at my notes?
I am actually, yes. I'll just let you continue that.
No, but that's the great question.
Yeah.
Because if there's multiple counties, you can obviously, under the statute, say, okay, well, it's 14 days. We're going to aggregate it because it's 3 offenses. But the question is not answered is, well, who's in charge? Is it the Rutland County State's Attorney, the Addison County State's Attorney, or the Chittenden County State's Attorney? And what county has jurisdiction? Right now in Vermont, there's only one entity with statewide jurisdiction for charging crimes, and that's the Attorney General. So what happens if Rutland State's Attorney says, well, we have a program that we want to put this individual in, and so we don't want to charge this. And the Chittenden County State's Attorney says the same thing, but Addison goes, no, we want to charge this. Whose case is it? That's not identified in the statute. The Chittenden County State's Attorney wouldn't have the ability under current law to take care of the Addison case or vice versa.
Do we have the ability to say in the statute something like, and this making this up, like the county in which the person is arrested, or is there some more deeper fundamental issue that, like, because they happen in 3 different counties, every state's attorney there, those 3 states attorneys get a bite at that apple?
In many ways, that's a policy decision, because that gets to my next point, and that is
We can go on the road with it.
because what happens when let's say you aggregate it, and even if there's agreement that it's going to be in Chittenden County, that means the victims from Rutland have to go to Chittenden County to testify. And so it's a policy decision. There is an impact on every level of the system. Same with law enforcement. They would have to go. And so the issue for multiple counties is one that you can solve it through changing whether it's venue provisions or statutory changes. It's something that you can identify. You can say that the county, whoever files first, gets to decide everything, and they'll have jurisdiction over other charges. You could come up with something like that, but that's really a matter of policy. And I'm sure the state's attorneys would want to weigh in on how that's going to be divvied up amongst their discretion, because they each have a constituency to address and answer to.
The obvious answer is that we have it per county. I mean, you get X number, but we can talk to state's attorneys about that as well. But yeah, definitely an issue. And Angela has a question.
Can I go back to I think the thing that you opened with about if there's, 3 different charges, each case has to be made and each count or charge has to be proven beyond a reasonable doubt. I want to make sure, I feel like I might be missing something, because isn't that the point of this bill? That all of that would happen in one place?
It's unclear that was all going to be, I couldn't tell from this whether it was intended, maybe some members felt that this was a sentencing enhancement, thinking that, well, wait a minute, they've already been convicted, therefore this is the 3rd time and we can use those other 2 convictions. And that's not the case. You are correct in how you look at it, and that is they all have to be proved at the same time.
Okay. Right, because that's my perception of one of the goals of the bill, because the idea being that it then compacts everything into one. Okay. So I think, yeah, thank you.
When we compact it, there may be a thought that, well, this is going to make it simpler, if you will, and this is going to make things run more smoothly. Therefore, we heard quite a bit a few minutes ago, and actually my entire week has been hearing a lot about backlogs. And we'll hear more about it next week, because this is something that Terry Corsons, who's here, and myself, we've been working on. If the idea is this is going to address the backlog and help streamline things, keep in mind that the moment a charge becomes a felony, it's going to put the entire case into a different category. Right now, for a retail theft misdemeanor, the defendant is not entitled to depositions. That means they can't go and call in the victim or call in one of Chief Burke's police officers to come in and question them under oath in a deposition. The moment someone's charged with a felony, they're entitled to do depositions. So there would be depositions. If the idea is to raise the stakes by having felonies,
Before you go on that next quick, I want to just ask a question about that one. So that would, I could see that definitely affecting, and it's a part of the criminal justice and the timing, when there's depositions, that would put more burden on the prosecutors and defenders, but wouldn't necessarily put more burden on the court, because the court's not involved in those depositions unless there's I'm sure there's some instances where there is.
correct. It would not be, I can't say that it would be a burden on the court. What I can say is that people would be asking questions much like we're hearing now, and that is, why is it taking so long? And the answer is, well, because they've got depositions. And the depositions you're going to be going 6 months, 9 months. So that the cases that Chief Burke talks about wanting to get moving quicker, please understand that the natural process of a felony is longer than that of the misdemeanors. And so there will be delays, and there will be impacts on, again, there will be, whether it's law enforcement, victims, or others. But those are policy decisions that you have to weigh as to, is this policy worth it when we're looking at the goal that we're trying to accomplish?
But in balancing that as well, I want to understand that I'm balancing what's the benefit for court resources. And I know there's timing is what we're looking at, definitely the timing overall. But if you have, instead of 5 misdemeanor cases that are on in the court, you have 1 felony case. Yes, the felony case, now you have a longer time period as far as a goal, even 365 days, or I think is what it is. And it certainly will take more time for that 1 felony to process because of the depositions. But there are 5 less cases in the court. And is that part of what we should be thinking about? Or is that in the end, it's 5 of one, 5 of another, or 6 of one, half of those?
I don't know that we could say that that's going to make a demonstrable impact on the docket.
Okay, no, that's, thank you.
The only thing I can say for sure is it will delay it. It will make the resolution of that 1 felony will take longer than the resolution of a misdemeanor.
Hopefully.
Exactly, yes.
Necessarily there right now.
You are absolutely correct. We're not there right now.
So, yeah, go ahead.
Yeah, the felony will take longer than the misdemeanor, but will the felony take longer than 3, 4, or 5 misdemeanors grouped? I know going out the year for a felony potentially.
If they were all going to, if every one of the, let's say 3 misdemeanors, if every one of them were going to be tried and go to jury trial, maybe not. It might not take longer. But what you might also have is the impact of, and this is a question you might want to ask the prosecutors and defense bar. If they have a case where they have to present 1 witness to prove, do they believe that's an easier case to prove than if they have to have 3 witnesses to prove? And the jury has to believe all 3 for each of the separate burglary or each of the separate retail thefts. In other words, there could be an impact on, prosecutorial decisions that might split things out anyway. And so this is a tool that you'll be giving the prosecutors. Whether they use it or not, we don't know.
Yeah, they would have to look at the 5 cases and maybe one of them is dud and they'll split the whole case if they bring it under the felony instead, right? So, yeah, Tom.
Could both of these bills be thrown in the trash and not needed if the court system was up to snuff with numbers?
It's what time? 3 o'clock? I don't lose my mind at 3 o'clock on a Friday.
I know the answer to it. Potentially.
There are policy reasons that many individuals would advocate for these types of bills. Irrespective of any of those policies, we still have to recognize that many of the concerns that have been raised this afternoon and in other hearings are that we need to move faster in the judiciary. We need to address the cases. We need to address the backlog. We need to have the confidence in our state that we're doing it right, and we're going in the direction that everyone's entitled to. And I think that hopefully on Wednesday after we've met, you'll understand that we are going in that direction and we are working in that way.
I'll put it in a different way that now it's, if we didn't have COVID, I guess you could say, because it's been a big reason for the backlog. If we didn't, I'll just say if we didn't have the backlog, I believe we would be in here testifying on a different bill other than misdemeanor retail theft.
Possibly.
Yeah, possibly.
Yeah, who knows? Okay, so,
And I would never say that there's a bill you should throw in the trash.
thank you.
Never hear me say that.
Mine and mine alone, welcome you to tell me.
So, additional comment, I stopped you
No, I'm-
going, I think you went to a next point when I
No.
cut you off.
Those were the points I wanted to highlight. But again, it's a policy decision. Actually, I take that back. There is something else that was mentioned. You wanted to hear about the cite and release? I know there was some questions about that.
I think your friend, Chief Burke, was trying to hang you up to dry on that.
That's no.
Yeah.
The reality is that when a judge is faced with whether or not to issue an arrest warrant, he or she has to determine what type of warrant should we issue. Are we going to impose bail? And if there's going to be bail, are we allowed what's the amount of bail? So under 13 VSA 7551 for expungable misdemeanors, for expungable crimes like that, bail cannot be more than $200. And so when the chief asks, or there was a question to the chief about why aren't people held on bail under VCRs for violations of conditions? Well, a violation of condition is an expungable crime. And under 7551, you're not allowed to impose bail unless it's necessary. And then at that time, the maximum amount is $200. And so there are restrictions. The cite and release warrants came up, they became much more used during the pandemic. There was delays. People were forgetting to come to court. And instead of having people get picked up and held on bail overnight, what was happening was the court started saying, well, if we just remind them, if you will, and give them the citation, they'll show up the next day and we won't have to have had the law enforcement officer drive them over to the jail. We won't have to have them held in jail that night. We won't have to have everything go on. We can just have them come the next day to court. And my understanding is that worked well for many individuals. Unfortunately, there's a number of individuals it doesn't work well from. And for the individuals who it doesn't work well from, the courts have to utilize the tools that are available to try to get them to court. If that's imposing a warrant that has bail, then that's something the judge has to consider. But it's not a category of offenses or a category of crimes. It's really something that's more of a balance that's determined by the judge and oftentimes requested by the state. The state will say, Judge, we'll ask for a cite and release. That can happen too.
Do you have a question?
No, asked and answered.
About this cite and release, is there, I think there was, someone alluded to a threshold. Does such a threshold exist? Like, so if you have so many failure to appear, it can just go on and
The court has to apply 13 VSA section 7554 when it considers release. And the court's going to look at those factors to determine if a warrant's going to be issued, what's it going to take to get someone back to court. And the court will consider a number of factors, but there's no, if you will, chart that says if this happens, you absolutely don't issue a cite and release.
Any other questions for Judge Zoney on this one? And we'll probably have you back when we're going to dig into a little bit more on H579. And we're going to be looking at this one, I think, through a good part of next week. So we'll try to get you in on one of those days.
Thank you.
Any other questions for, I don't see any. And I think we will schedule Falco from ACLU for next week. I myself am flagging. So anything else before we adjourn until Tuesday at 1? Because we have training on Tuesday after the floor. So it will be until Tuesday afternoon. 10 o'clock on Friday.